Hello, legal warriors. How to get your felony charge reduced to a misdemeanor? That's a really good question. And if you're interested in this question, stay tuned because this is the video for you. My name is Lance Fryrear, and I'm a defense attorney in Linwood, Washington. I have a law firm that's been defending people charged with crimes for more than 20 years. And let's face it, how to get your felony charge reduced to a misdemeanor or even dismissed altogether is a very important question. And the first thing I let people know is not to panic. Don't panic. It's a very serious situation if you've been arrested for investigation of a felony or you're actually charged with a felony, but it is not hopeless. Good attorneys all throughout Washington state can get felony charges reduced or dismissed, but we're gonna need some help from you. We can't do it for every case, but how do you do it? What's important to know? Well, the first thing you need to know is whether or not you're actually charged with a felony yet. Just because you're arrested for a felony does not mean you're actually charged. A law enforcement officer has the power to arrest someone for investigation of a felony, but they do not have the power to charge the felony themselves. You might say, Lance, but I was in jail for the felony. You mean I'm not charged? No. When you get arrested, there's usually going to be a first appearance and then a second appearance, and the prosecutor has basically 3 court days to either rush file a felony charge on you or let conditions get released, and then they have usually up to 3 years to decide what to do. So if you're not actually charged with a felony yet, the best thing to do is try to get some attorney help to avoid ever being charged to begin with. And that can happen. But let's say you're already beyond that point and you are already actually charged with a felony. You've had an arraignment or an arraignment is set. And again, arraignment is something where we say not guilty to charges and the new court dates happen. So what type of felony are you charged with? That's the next thing you need to consider about how to get your felony charge reduced to a misdemeanor or even better. So is it a drug felony? Those, if we're not talking about selling drugs, could be a little bit easier to deal with than other types of felonies. Is it a crime of violence? Those are typically going to be harder to get off of a felony charge, although evidence is more important there. They're harder to negotiate based upon equities or what your prior history is. Those are more evidence-based cases. Or is it a property crime? And if it's a property crime, how many property crimes? The bad news about felony property crimes, so they're usually multiple crimes. And so the more felonies you have, the harder it is to end up with a misdemeanor. So definitely we have to think about what type of charge it is, and then we can give you a better idea of what you need to do. Drug charges, we might want to put you in some type of drug treatment classes, and charges involving assault, we might want to put you in some other type of treatment classes, like if it's domestic violence case, maybe you want to put you in DVMRT, domestic violence moral recognition therapy. We've got a video on that, but depending on the county, some counties that's really important for, such as King County, and some counties maybe don't care so much about that, like Snohomish County, at least in my opinion. So once you know what type of charge it is, then felonies are harder to negotiate without actual evidence on your side. And you might think, Lance, aren't all cases about evidence? Well, many misdemeanors can be negotiated successfully regardless of the evidence, just because the nature of the crime, they're less serious, at least if you have a good attorney. Felony prosecutors' hands are tied a little bit more, and you're going to need to really gather some evidence to help your attorney. So, if it's an assault charge, are we talking a self-defense type defense? In other words, they attacked me first and I was just defending myself, right? Is it a drug charge? Hey, I was not intending to sell drugs. I might have had a scale or something, but that's so I don't get ripped off when I buy drugs. And I might have had a little bit more than you might think is normal, but maybe I buy in bulk. I don't know, but think about what the evidence is. What is your use history in that case? And then maybe we just need to record some evidence about that you just simply didn't do what they say you did. Let's say it's a burglary charge, and burglary requires you to enter somewhere with an intent to commit a crime. So maybe you're on the property looking around for something, but there's no intent to commit a crime, no intent to steal something. Well, that could be a defense, but what's the evidence of that? What evidence can we gather? Do you have some prior communication with someone about why you were going to the property? That type of thing. And finally, another good thing to think about, if someone is sort of pointing to you doing something, but no one saw you do it, they're just assuming that it was you based upon something you've said, think about alibi, okay? Where were you, and where can we show that you were at the time of the supposed crime? If it's a felony violation of a no contact order, maybe you weren't even in the city where the protected party says you were, or maybe it was not you that liked someone's Instagram post and for a felony violation if you have prior violations of a no contact order. So that's something to think about. How else can we help you get out of a felony charge, or any attorney, not just us? Well, if the case involves witnesses that are not professional witnesses, and the majority of felonies do not involve professional witnesses. When I say professional witnesses, I mean police officers, right? Most felonies are not on view by police officers. Eluding a police vehicle could be, if someone is selling you drugs or catching you buying drugs, that could be. But think about it. Most felonies might be an assault type crime or a theft type crime. And usually police officers investigate that, but they're not the primary witness. So think about the primary witness. What type of witness are they? Are they going to likely want to appear to testify against you, or are they type of person that isn't going to want to deal with that type of trouble, right? Are they located locally, or are they out of state? Are they in, Florida, and are they going to want to travel all the way to Washington State to do that? How reliable are they? What is their lifestyle like, right? Are they a person that isn't reliable, is more transient, is hard to find? Well, that's something that your attorney is going to take into account when predicting what's likely to happen at a trial, so we can negotiate with the prosecutor. And finally, what's the criminal history of this supposed witness against you? What we found is people with a big criminal history, they don't really feel comfortable coming to court. They don't want to be part of the system. And sometimes an attorney can use their own criminal history against them, and they don't want to deal with that. So, think about that witness, because you're going to know more about them in some cases than your attorney will. And so you want to give that information to your attorney. The next way that we can try to help, and what you want to think about is the type of crime you're charged with the type of crime or the type of jurisdiction that there's some alternatives to prosecution? If it's a possession of drug crime, can we get you into drug treatment and have you do drug court? In drug court, you could end up getting all your felony charges dismissed. Can we get you in an adult diversion program? Some counties, like Snohomish County, has something called therapeutic alternatives to prosecution for certain types of charges. Usually has to be property related, mental health related, drug related, but basically we may be able to get you into a program where if you go through counseling and do things you need to do, you might be able to get your charge not just reduced, but dismissed. Also, are you in the type of county, and do you have the type of charge? You're going to need to check with your attorney, where you might be able to get an accelerated offer to a non-felony charge. That's what they call it nowadays in Snohomish County. In King County, it would be called an expedited offer, and other counties may have similar things. So, you may be charged with a felony, but you might already get an offer out of the gate for a non-felony depending on your history, what the evidence is, how strong it is, and how busy the prosecutor's office is, right? That makes a difference. So how long is that going to take before you're charged? I'm just going to jump back. Just remember, if you get arrested, you're not necessarily charged right away. It could take a year, 2 years or more before they charge a crime. So make sure to reach out to an attorney when you're dealing with this. Finally, one of the best ways to get your charge reduced is to stand up. stand up to the prosecutor and set your case for a trial. Now, it's more risky to do that, and it's typically not your first approach to a case, because the bad news is that in many types of cases, a felony prosecutor has the ability to add additional charges. In many, many cases, if we pulled a weapon, maybe there's more than one person there, so there could be more than one victim. They could add a gun enhancement. In an identity theft case, maybe there's 5 transactions, they've only charged 2. And for felonies, that's a serious threat. Misdemeanors, adding extra charges is a threat, but it's not the biggest threat, because adding misdemeanors doesn't change what's called a standard range. Okay, felonies in Washington State have a standard range sentence based upon the seriousness level of the charge and how many prior felony adjudications or convictions you have. And the bad news is, though, the way they count those rules here in Washington State is if you're charged with multiple felonies at once, they sort of add those up against you currently and count them as your past record, assuming you're convicted. So if you only have one charge and you have no prior history, that's a 0 offender score. But if they give you 2 charges, now they say, okay, this one's 0 and this one's 1, so you've got a 1 offender score if you're convicted of both, so it bumps you up. And really bad, some types of crimes, sex offenses and other types of crimes, an extra charge doesn't count once, sometimes it counts 3 extras. So the power of a prosecutor to add charges is serious. So if you're thinking about setting your case for a trial, make sure you check with your attorney, hey, do I have any more exposure to additional charges? So why does setting a case for a trial sometimes help you get your case reduced? Well, everybody's busy in the system. I was a prosecutor for 7 years, and anyone who's been in the defense or prosecution business knows is when we look at our police report to begin with, we sort of make assumptions and everything there is correct, and we don't think about it in the same way because as setting it for a trial or trial evidence, because we have so many cases, and that counts for the prosecutor too. So we've had cases where the prosecutor would not budge, on a felony assault charge, and then we get near a trial, we finally get to witness interviews, and typically you can't interview witnesses with prosecutor help, at least unless the case is set for a trial. And sometimes that witness will fall apart, and sometimes the prosecutor will finally hear the quality of the evidence as it exists in real life versus the fantasy perfect version that's been written down in the police report. And sometimes those practicalities and also the caseload of a prosecutor will make them behave in a more generous manner later on in the case. Now, it can get worse too. I've had cases due to a witness interview go from 1 level felony to a worse level felony based upon what a witness said. So, practice this at your own risk, but that is a way, as a last resort, to try to get your charge reduced. And if you don't get it reduced, if you're doing this, you better have a chance of winning, or I wouldn't recommend it, because typically speaking, it's going to get worse if you go to trial and lose than it will be if you're resolve the case in some other way. Well, you may go to trial and win, so check with your attorney. Do you have a human story that sounds true enough emotionally that a jury would believe your human, emotionally true story? Something that's way out there or wacky, people are just going to buy onto to a version that they can relate to, right? Because when you go to trial, you're testing the version of the state versus your version, or you're testing the version of the state versus what else could have happened with that beyond a reasonable doubt standard. So those are the ways that I suggest how you can get your felony charge reduced to a misdemeanor. It is not easy to do, but it does happen quite often with the right case and the right team of attorneys. Usually you're going to need a team because felonies are serious. A prosecutor has a major team in the felony unit working against you. So if you found this video useful, please like and subscribe. More people will get to hear it. And if you're in this situation, feel free to give my office a call. Now, we're going to be selective about what cases we take because we try to take cases where we think we can help. But if you have a type of case that we think we might be able to help, we'll set you an appointment. We'll listen to what happened. We'll see if it makes sense for us to get involved. And if so, we'll do our very best and we'll be there for you. Thank you.